आवाम के टैक्सेस पर चलने वाली अदालत क्या मेरी मर्जी पर चलेगी? सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर केस की समाअत के दौरान चीफ जस्टिस काजी फाइज ईसा का इजहार बरहमी। वकील ख्वाजा तारिक रहीम ने कहा कि जब मैं चीफ जस्टिस हूँ तो मेरी मर्जी नहीं, दरख्वास्त गुजार चीफ जस्टिस को एहतसाब से बालातर बनाना चाहते हैं और इस वक्त आपको लिए चलते हैं बराह रास्त, जहाँ एक बार फिर समाअत शुरू हो गई है।
And if my lords and your lordships have any questions, they may be raised, may graciously be raised once I have concluded my submissions. I'd be grateful. My lords, my first submission, your ladyship, my first submission is on maintainability of these petitions.
The speaker,
my lord,
the red light is not on.
It is, but it's just, I've just pulled it closer. In paragraph number 6, page 3 of volume 1 of my submissions, page 3, paragraph number 6.
Page 3, paragraph
6, volume 1. My lord, I have sought rejection of these petitions on the grounds on maintainability for failing to meet the test criteria laid down under clause 3 of article 184, which is the matter must be of public importance, first. Second, it must relate to enforcement of fundamental rights. My lord, my first submission on whether these petitions raise or they raise any issue or question of public importance. My lord, my learned friends, the counsels for the petitioners, they have largely, their case is rooted in lack of legislative competence, not necessarily objecting to the contents, all of them, but it's essentially rooted in lack of legislative competence of government in terms of Article 191. And the argument, my lord, is that because the powers and because this honorable court in 1980 had made rules, therefore the field stands occupied and in any event could not legislate. My lord, firstly, insofar as public importance is concerned, my lord would have now gone through the law and my lord would see that this law in fact deals with the concentration of powers, barring one provision, but concentration of powers in one office. What this law endeavors to do is, it democratizes this institution, brings more transparency, and structures the discretion, which is something, this structuring of discretion is something which has found favor with this court. The 7 principles enunciated in Amanullah case, PLD 1990, Supreme Court 1092.
PLD 1990,
Supreme Court 1092. Open policies, open plans, transparency, and so on, which this court has held that it is required of every, and of course it was with regards to the powers that the executive exercises. Now these are all administrative powers we are talking about. This law deals with largely, barring, of course, Section 3. There was a question that came, was raised. I'll address towards the end, and Section 5, which I will address separately.